Adriana Brava. A deposition is an opportunity for the insurance company to interview you and get your side of the story. Formal proceeding in an informal setting, meaning you're not going to be in a court, you're not going to be in a chambers with the judge. You're likely going to be in an office with your attorney, the insurance company attorney, and a court reporter who's going to place you under oath. The truth, and that is the number one rule in a deposition. Always make sure to tell the truth, because there's no point in trying to exaggerate or lie or cover up any of the facts in your case. A lot of times these attorneys, they already know this information. They have access to your medical records. They have access to prior court filings that you may have had, prior injuries. When you take your deposition, the number one thing, like I said, is to tell the truth. Now, there are some other things you could do to help your testimony move along as quickly as possible, and that is to always respond with a verbal answer, meaning yes or no. If you nod your head or go like this, any gestures are going to be observed, but they can't be taken down by the court reporter. The court reporter will take down everything that you say because they're creating a record. That record can be available later on in case you did not tell the same version of events. They can use the deposition transcript to discredit you. So you want to make sure it's a clear deposition transcript. Your best bet is to keep your answers short and to the point. If you can answer with yes, no, I don't know, or I don't remember, those are fabulous answers. They're going to help keep you going in a question and answer series. If you provide more information that's required, that can potentially be used against you because you're giving the attorney more information to work with, and they're going to maybe possibly ask you follow-up questions. So do yourself a favor and just answer yes or no. It will go by faster, it will keep things fluid, and you're going to potentially help your case by just keeping a very clear record. You want to avoid gestures also because if you're stretching your arms or moving around, the insurance company's attorney is going to be making observations about you. So make sure that your gestures and observations that are made about you are consistent with your testimony. It's very important that you actually state for the record which body parts you're talking about when they question you about where you were hurt, which body parts you were hurt. If you say it hurts here and here, in the future, that's what someone's going to read in the deposition transcript. It's going to say it hurts here and here. They're not going to know that you were pointing to your left shoulder or right shoulder. So it's very important for a clear record to specify all the body parts that you're talking about. And remember that your left shoulder is different from your left elbow, which is different from your wrist and fingers and hands, etc. So those are sometimes things that can trip people up because they'll say, my arm hurts, and maybe they meant like from the fingers all the way up to the shoulders, but that's not what is said. So be very clear as to which body parts you state that you are hurt. Because if you forget to say something at your deposition, and later on it's discovered that you said something else to your doctor, or you say something else in your testimony, that can be pointed out and hurt your credibility. So please remember, each body part has its name, and you would be wise to include all the body parts when you're being questioned. Again, you want to avoid just nods of the head. If you do that consistently, you're going to be reminded by the other attorney to please have verbal responses. They might say without a yes or a no. They're not trying to harass you. They're just trying to keep a clear record. And so, as I said, what you might want to visualize when you're talking about your body parts is that you're talking on the telephone with someone who can't see you, or that you are talking to a blind person who can't see you. That'll force you to verbalize your body parts. Now, they will get into some background questions about you, maybe where you lived previously, any last employment for the past 10 years, things like that. There's no reason for you to question why they're asking you, because the number one thing that will interrupt your thought process is if you start questioning the questions in your head while you're supposed to be answering. You're going to have an attorney there for a reason. Listen to your attorney. They're going to do a great job to defend you. If there's an objection, they'll state it for the record. And if you are going to be instructed to not answer that, then wait for your attorney's objection and let them make that objection. So that means you need to stop talking when you hear your attorney talking. And also, that just goes to the next point, that you can only talk one person at a time. So when the person is questioning you, and the attorney is questioning you, don't try to talk over that person. Don't try to start answering before the question is complete, because if you do that, it's going to keep a very unclear record. You're not going to really fully understand the question if you start answering before it's even completed. So you're not doing yourself any favors. Allow the person to finish the question completely before you start answering. And if you consistently forget to do that, you're going to be reminded, and also the court reporter will probably be very annoyed because they can't take down two people talking at the same time. So please remember to keep your questions and answer separately and wait your turn to speak. That you are required to give your best recollection of events, your best estimate of times and weights and measurements. You're never required to guess. Now, there is a difference between a guess and an estimate. If I asked you, how much money do I have in my pocket? There's no way you're going to know. It would require you to guess because you don't even know if I have money in my pocket. But if you have some change in your pocket, you can give us an estimate of how much change you have, because you may not necessarily know that it's 76 cents, but you might have a rough idea. So anything that's required you to guess, you can say you don't know, because it would be requiring you to guess, and nobody wants you to be guessing. Now, if it's something that's required for an estimate, for example, have you ever been in a car accident? And the answer is yes. The next question might be, when was that? If you don't know, they'll still try to pin down at least an estimate. Was it more than 2 years ago, more than 5 years ago, less than 10 years ago? They're not trying to harass you. They are just trying to get your best recollection, which they are entitled to. You have, after all, filed a claim for workers' compensation benefits. And so they're also entitled to certain information, and they also have due process rights. So don't take any of the questions personally. Most of the questions are extremely generic, meaning that they're asked of all people in workers' compensation. At least in California, they are very basic and they are very routine. And as I stated, they'll get into background questions. A lot of times, like I said, people don't want to, or they might start thinking, why are they asking me? They start questioning it. Don't do that, because there usually is a good reason that they're asking you these questions. There's certain ethical codes that attorneys have to abide by, so they can't just ask you questions to harass you or to belittle you or to annoy you. So like I said, your attorney will be there, and just trust that they're going to be defending you. So for example, one of the background questions might be, do you have any children? Do you have any minor children? Do you have any adult children? What are their names? You know, people, when you ask about their kids, tend to get very, very touchy. They don't like to involve people into their legal problems that they may feel don't have any reason to be involved. Now, sometimes you don't think ahead of time. And for example, if you were to pass away from surgery gone bad, they're going to need to know who are your dependents. So if you said you don't have any dependents, you don't have any children, then you might be doing your children a disservice, because later on they may want to file a claim on your behalf if anything were to happen to you. So again, it's not your job to question why they're asking you the questions. It's your job to answer. So stick with that and you'll be fine. Stick with short answers like yes or no. I don't know, I don't remember. Those are very direct. You're being cooperative, and it's keeping the interview in a very fluid manner. If you need to stand up or sit down to answer your questions, if you're uncomfortable or physically, just need to get stand up, change positions, you can do that. As long as the court reporter could hear your voice speaking, as long as everybody else hear you speaking, it's okay. However, like I said, remember that you're going to be observed, any gestures you're making and things like that. That said, you don't want to overly exaggerate any symptoms or appear to be overstating the extent of your injuries. That is usually the number one way that people get themselves in trouble in a deposition. They exaggerate because that's what we do in everyday language. So I may get home and I may be very tired, and so I might say to my family, I'm so tired I could die. Now, obviously, that is meant to be an exaggeration. It's meant to say, hey, I'm really tired. I might need a break here. So in a deposition, you can't do that. If in a deposition you say, I can't lift over 5 pounds, that means you can never lift over 5 pounds. So if you say, I can't bend over, that means you can't bend over. I would say, let's be more accurate. And if you avoid doing an activity, state that. I avoid bending over, or I avoid lifting things that are too heavy. Or explain the situation. If it makes your symptoms increase or it aggravates you in any way, you can say that, that lifting things causes you to have increased pain or things like that. But if you're just deciding that you want to say, I could never do this and I can never do that, that's really going to hurt you if the insurance company has an investigator on you. And even if you just do it one time, that's going to make you look like a liar. So avoid doing that. Avoid jumping to conclusions and using terms that are extremely absolute, like never and always. Again, in that situation, you do want to try to be more accurate than what we would in normal everyday language, because that is going to tend to put you up against the wall. And if the insurance company catches you doing that and you said you couldn't do that, it's going to make you appear like you were lying on purpose. So just remember to explain things. Those are some basic rules. This is not all inclusive, but these are the big ones that will help you. Now, when it comes to what are your job duties, you do want to elaborate a little bit on that, because what your job duties were, we don't know what your job entails. And the only way we'll know how you could potentially have gotten hurt, for example, if you have a repetitive injury, is if you tell us what are your duties. What did you have to do? Did you have to constantly lift things? Did you have to manipulate things with your fingers? Did you have to use force, excessive force? So again, in that situation, that's okay to explain what are your job duties, what are your symptoms, what are your body parts that are hurt. When we're talking about symptoms, nobody can put words in your mouth and nobody can testify for you. That's your job, to be able to express what you feel. Do you feel tingling? Do you feel pins and needles? Things like that. All of that are things that you're going to have to express and you're going to have to explain, because nobody else feels the things that you feel. And if you don't tell us, then it's just not going to come out in the deposition. So really, just relax. Understand that this is a normal process. Understand that this is not anything personally directed against you. Nobody's out to get you. This is a normal part of a workers' compensation case. Okay, I hope this video helps you. If it did, and you were able to take away something valuable that helped you, please let us know in the comments below. Take care.